Good evening, ladies and gentlemen. Welcome to the special webinar brought to you by Buckinghamshire New University and IDMNC International. Tonight, we delve in a critical and a sensitive topic, the Israel Palestine war, from the point of view of international law and international humanitarian law. Mayantha, Warnakulasooriya, your moderator for night. So, ladies and gentlemen, we've heard about these critical situations. Most of the time, people on social media and media point their fingers to people and tell this is something wrong with yourself. We, as the people who are working in the legal profession and willing to go to that stage, we have to be aware and be careful about these sensitive topics while having a good understand and a knowledge about these topics. For that, today, we are organizing this webinar with two esteemed guests who got a proper knowledge about this exact topic, who is going to let you know what is the exact happening there and what are the laws and regulations being interfered in this exact problem. So today we have Dr. Punsara Amarasinghe and Ms. Eranga Dissanayake. Before we begin, let me express our heartfelt gratitude again to the Buckinghamshire New University and IDMNC International for making this webinar possible. Now, further ado, let me introduce our esteemed speakers. First, Dr. Punsara Amarasinghe is an attorney at law and lecturer at the General Sir John Kothalawala Defence University. And also we have Ms. Eranga Dissanayake. She is also an attorney at law and lecturer at Open University of Sri Lanka. They will be sharing their insights, thoughts about this conflict and also the legal terms and legal conditions and how the international law and international humanitarian law is going to interfere in this problem. So welcome you both to the webinar today. And first, I would like to ask a question from Ms. Eranga. So, hi, Ms. Eranga. Good evening.
Good evening. Okay.
Okay, Ms. Eranga. So, we've heard these words, international law, international humanitarian law. I would like to know properly what is this international law and how this is going to work. And are there any special institutes to execute the plans and the aims of these laws? And we all would like to hear from you, madam.
So thank you, Mayantha, for the very first question. And before answering the question, I want to thank the organizing committee for inviting me for this timely discussion as a panelist. And I feel privileged to be a panelist with Dr. Punsara Amarasinghe as well. So thank you very much for the opportunity. So I mean, right now the world is going through a very tough time, and there are a lot of wars happening all around us. But today's our topic, this Israel Palestine war, is considered to be one of the top wars in the world, and one of the on the top of the list now. So everyone is talking about this. So as people like who are looking at this issue with a low background, definitely we need to talk about this Israel Palestine issue in an international law perspective. So to talk about that, before enter into the issue, basically we have to have a kind of a good understanding about the terms. I mean, the international, what is international law? Definitely the difference between international law and the domestic laws, because most of the people, they are familiar with the national laws, especially the people who are having a non-law background. So answering the question, I think that there are two parts. What is this international law and how it works, and also what's the difference between this international law and national laws. Okay, so to answer the question, I mean, let's try to build up a definition first for international law. So we are Sri Lankans, right? So we live in this Sri Lankan territory, and we are governed by, we are controlled, and we are regulated by this so-called Sri Lankan law. So as Sri Lanka, we have this common law. And as Sri Lanka is a multicultural, multilingual, or multi-ethnic country, so we do have these special laws as well, Muslim law, or Kandian law, Thesawalamaya law. We have a set of laws. So commonly we call this Sri Lankan laws. So this Sri Lankan laws applies to all the Sri Lankan citizens within the territory. And the citizens and their properties, their actions are governed by this law. So this law is called as, specifically we identified this law as domestic law or national law of Sri Lanka. So this won't be going beyond the territory of Sri Lanka. So we cannot activate this beyond our territory. So today we are going to talk about this international law. So we have this again, we have this in international law, we have this concept called interdependence of the nations, right? So that means no country can exist in isolation, right? So we are, today we are in a very interconnected world. And I mean, one nation's success is always tied to its relationships and collaborations with other nations, right? So we cannot go isolation. I mean, we have to deal with other countries if we want to survive. That means Sri Lanka is just a one nation. We have 196 nations. According to the UN membership, we have 196 countries in the world. So these countries are interconnected. They have different kind of relationships. Maybe it's political wise. Sometimes the relationships are cultural wise, socially. Sometimes they are dealing with trade and for commercial purposes sometimes. So for, they have different kind of relationships, right? So to govern these relationships as well, I mean, there are 196 countries, sovereign states. We call these sovereign states because one country cannot interfere to another nation's actions or another nation's control, right? So they have their rulings, they have their territories, and separately, and they have their own sovereignty. But when it comes to the relationships between these nations, we should have some set of regulations or some set of laws or some kind of agreements or principles to govern these relationships among these states, right? Among these sovereign states. But simply we can say, for the definition, international law is a set of rules, agreements, or principles that governs this relationship between sovereign states. But when it comes to this modern interpretation of international law, now we have these international organizations, right? UN, United Nations, International Labour Organization. So we have a lot of international organizations. When it comes to the Israel Palestine war, sometimes this UN, the United Nations Security Council, intervenes, right? So definitely, definitely the countries also have to deal with international organizations as well. And also sometimes these countries deals with individuals or entities with international legal personalities. So now this international law definition has been extended beyond the relationship between sovereign states up to international organization and sometimes individuals. So basically, this set of rules and principles that governs relationships. So that's the definition for, I mean, international law. Then we have to, so within my answer, then we have to identify how this international law derives, because to talk about the international, the law which applies to the Israel-Palestine war or whatever, we have to find the origin, the sources of international law. So basically, the relationships among all the states, these states maintain their relationships based on the treaties or the conventions they agreed upon. I mean, Sometimes, for an example, Sri Lanka is having a bilateral or multilateral agreement or a treaty, international treaty, or a agreement with another nation, some with some other nations. Sometimes we are binding with some conventions. We have been party to signatory parties to the conventions, and we are binded by those laws and regulations of those which included in those conventions. And also, apart from treaties and conventions, we have these customary practices, right? And sometimes the general principles which has been accepted by nations, right? So through this, especially there's this Article 38 of the Statute of the International Court of Justice, where specifically mention the sources of international law. So it says that a certain set including these treaties, conventions, customary practices and all. So however, if we need to find out the laws or that international law or that agreements or the principles, we have to look at all these sources, right? Next, I mean, how it works, like to identify how it works within this international arena, we have to look at the scope of international law. Simply, I mean, I told you before that there are a lot of like different kinds of relationships between these states. That means, so when it comes to the Israel Palestine, our topic is based on Israel Palestine war. So my explanation is just an introduction. I mean, Dr. Punsara will explain on the laws deeply. I mean, when it comes to the scope of the international law, definitely the Palestine-Israel war is based on an international armed conflicts. That means a conflict between two countries, two international sovereign. I mean, we cannot say the Palestine is still not recognized as a state. So, I mean, it's kind of an international thing happens between two international parties, right? So not only armed conflicts, right? So within the scope of international law, it includes sometimes diplomatic relationships. I mean, if we can have good diplomatic relationships between these states and these parties, then we won't be able to see this kind of wars or armed conflicts, right? And sometimes we see a lot of human rights violations under this scope of international law. I mean, we can see a lot of human rights violations happening within this Israel-Palestine war. So we are talking about these human rights violations. This comes under scope of international law. And environmental issues, sometimes some very famous trails melt arbitration. Sometimes we know an environmental issue happens between Canada and USA, two different sovereign states, right? So yeah, different kind of relationships. I mean, maybe it comes under the scope, diplomatic relations, sometimes trades, human rights, armed conflicts, environmental law, and many more, right? Okay, so here, then I think I have time. I'm just summarize the latter part of my answer. I mean, next we have to identify the difference between international law and domestic law, right? So basically the difference between these two based on the scope, right? So I told you earlier also, this the international law actually governs the relationship between sovereign states, international organizations, and sometimes occasionally individuals or entities with international legal standings. But when it comes to the scope of the domestic law, that it governs only the people, the citizens, or the actions of those specific country. I mean, it's limited to the specific country's borders, and it applies to the individuals or the organizations and entities within that territory, right? It's limited to the territory. So that's the difference. And also when it comes to the participants, the citizens in the domestic law, and when it comes to the international law, the sovereign states. And also, when it comes to the creation of the two laws, international law, we discussed this, agreements, international treaties, conventions, agreements, customary practices. And the special thing is, these treaties are binding if voluntarily ratified by participating countries. That means if a country is just ratify it, then only they are binding, and then only they should adhere to that international law, and they should impose their national laws according to that international law. But here the main difference between this two, international law and domestic law, is this domestic law actually lacks a centralized enforcement mechanism, right? That means we have laws, international law, we say we have a lot of laws according to the treaties and convention, but we don't have a very centralized enforcement mechanism, because the compliance, actually in international law, these compliances relies on sometimes the diplomatic channels, sometimes international organizations, or maybe international sanctions sometimes. So then there you may have the question, yes, we do have these international courts, ICJ, International Court of Justice, International Criminal Court. Can't we take those two as an enforcement mechanism? But the problem is, actually, international courts exist, but it actually have limited jurisdiction, and that also relies on the voluntary participation. If they won't be a party to ICJ, we cannot apply that enforcement mechanism, right? But when it comes to the domestic laws, yeah, we in Sri Lanka, we have our own judicial system. We have defined courts, from primary courts through Supreme Courts. We apply all those laws within our territory, within our property matters or family matters or whatever, right? So, but when it comes to the international law, we don't have a very centralized enforced mechanism. Yeah, and apart from that, this within the international law system, they respect the sovereignty of the states, but sometimes in the domestic law, always the sovereign states have the authority to create and enforce their laws, generally without requiring external consent for internal legislation, right? So those are basically we can consider as the differences between international law and domestic law. I think I answered your question, and I don't think I took too much time from this discussion. I mean, our main point is Israel Palestine war. This is just an introduction. Okay, thank you.
Thank you so much, Mr. Eranga. Before we are peeking into this exact problem we are having about the Israel and Palestine war, we should have a proper knowledge about what is international law. Without having that proper knowledge, we cannot go there. For that, we had an elaborative explanation by Mr. Eranga about the domestic laws, the international laws, the sovereignty, how this is going to work, how the country is being bound to these laws. And it was amazing. And thank you so much for that elaborative explanation. So again, now we are going to have a question from Dr. Punsara. So we heard about the international law. Now we know what is international law. And again, on the flyer and on social media, we saw they are speaking about something international humanitarian. So Dr. Punsara, is these two different concepts, or this is the same concept, we have two names? Or what is the difference between these? I would like to know about that point from you now.
Okay. Yes, Mayantha, thanks a lot for raising this question. Actually, this is a very interesting question that continues to invoke arguments and debates in the legal academy. I think my colleague, Ms. Eranga, gave a wonderful explanation about public international law and the distinction between international law and the domestic law, and what are the basic sets and norms and rules of international law. So my task is very much easy now, so I will not take much of your time. I will straight away go to explain the distinction, the main difference between IHL, which stands for International Humanitarian Law, and international law. So basically, international humanitarian law needs to be understood as a branch that comes under the general purview of international law itself. So, as a matter of fact, international humanitarian law is a set of rules that seeks to provide justification with regard to the involvement of the combatants and the non-combatants during the war situation, military situation. So that is the very, I would say, non-legal explanation that I can craft for the general audience. But before I move further in terms of discussing about the principles which have laid down the foundation for the development of IHL, I need to emphasize that international humanitarian law itself arose from international law itself. I mean, I would like to repeat that argument for the clarity of this audience, because we need to understand, if you look at the international law, so from a proper, the Westphalian standard, from a Western point of view, which dates back to the formation of nation states in 16th century, and then we have Hugo Grotius, who talked about the laws of war and the nation's the territorial boundaries and etc. etc. So we need to understand the moment when Grotius talked about the laws on war. So that was a starting moment, that was a starting pillar which provided the very genesis of international humanitarian law. But don't get flustered. This idea of IHL did not develop until the latter part of the 19th century. So between 16th to 19th century, it was international law as an umbrella network that continued to govern the state affairs, to clarify the international state affairs, the diplomatic affairs, and also to a certain extent, the international law's authority was applicable to a certain extent towards the armed conflicts, the warlike situations, the international armed conflicts, interstate wars, and etc. etc. So that is the very premise that we have to comprehend with regard to international humanitarian law and international law. So again, if I just clarify, if I try to make myself more simplified, we have to understand IHL has derived as a particular distinct branch within international law. I hope that I have made myself correct, right? So with that, we need to now proceed to the, I would say, a little bit of homework, the technicalities of the subject, IHL, International Humanitarian Law. So how this subject came into being, what sort of legal mechanisms, legal instruments provided the authenticity for the development of international humanitarian law. So as I told you, like by the 19th century, there were two main documents. One is called Martin's Clause. The second one is called the First Hague Convention. First Hague Convention, 1899. So in 19th century, you find that the continental Europe was on a brink of interstate warfares as a result of the emergence of Germany and Italy as two separate nation states, which finally challenged the continental authority held by the Austro-Hungarian Empire. So there was a tremendous series of catastrophic wars. I mean, just like what we are witnessing today between Israel and Palestine, but contextually it was rather different from what we are witnessing today. So in 1866, there was something called Solferino, and 1870, the Battle of Sadowa. So a series of wars pushed the European nations to the brink of war, to the great catastrophes. There were a wave of bloodshed. So that, I mean, actually, it invoked dialogue among the nations in Europe with regard to setting up a unilateral consensus among the nations in handling the warfares, or else the state behavior towards war. So that was the starting point of international humanitarian law. And in the words of Antonio Cassisi, who is one of the classic examples, the classic modern writers on international humanitarian law, he describes this particular moment occurred in 19th century as the cradle of IHL. So that was the genesis, that was the starting point, that was the point in which international humanitarian law jumped out of the bag from international law. Okay, so 1899 Hague Conventions. Now again after that we have 1907 Hague Convention. So within that the span of time, so international law and international humanitarian law began to develop as two separate, two distinct tools, but interconnected. That is something that we should not confuse ourselves. Interconnected in the sense the international humanitarian law receives its legitimacy through the pillars of international law in general. So after that, in 1949, the four Geneva Conventions can be described as the key position, the key moment with regard to the legitimacy of IHL. The four Geneva Conventions, 1899 Hague Conventions, Martin's Clause, 1907, the second Hague Conventions. Those are the statutory mechanisms that you need to understand about the general basis of modern IHL. So besides that, we have something called International Convention on Red Cross, International Committee on Red Cross, which is commonly known as ICRC. And after that, in the aftermath of the Second World War, international humanitarian law began to further develop into different domains. So what happened after the Second World War is, so instead of going through conventional series of wars, such as interstate wars, the modern world began to see a different array of wars, not entirely international armed conflicts. So as a result of the decolonization and emergence of the global South, we step into a stage filled with internal armed conflicts. So if you look at the civil war, the ethnic clashes lasted in this country for 30 years, for past 30 years. Was it an international armed conflict? No way, it was an internal armed conflict. So if you look at the situations in countries like Rwanda, and even in countries like the Bosnia, even even what we are witnessing in Kashmir today is to a certain extent not entirely an international armed conflict. So my argumentation is, after Second World War ended, the nation state stepped into a more complicated stage in international humanitarian law affairs, as we were approaching something called internal armed conflict. So in that context, there was a question arose within the academic circle: does IHL have sufficient instruments to cover internal armed conflicts? Does IHL provide a solid mechanism to protect the well-beings of the civilians, injured soldiers, body combatants, and all these respective parties during internal armed conflicts? No. Because why? Again, if I get back to the central thesis, in 1949, IHL provided only the four Geneva Conventions. None of the four Geneva Conventions explicitly related to the internal armed conflict. So where lies the problem? So when this problem emerged in the aftermath of the Second World War, the ICRC and Geneva Convention Committee stepped into another juncture in 1977. They provided two additional protocols. So the second Geneva Additional Protocol, adopted in the year of 1977, which continues until this day, covers the internal dimension of internal armed conflict. So, I mean, all in all, I can now say that international humanitarian law is nothing more than a continuity of set of rules adopted by the nations through various customary international law practices and treaties derived from 1899 until 1977. So did it stop in 1977? No, it further evolved. So we have now the Tallinn Manual that covers the warfare, the drone warfare, and also we have a Budapest Protocol which discusses the dubious manner of the hybrid warfare. And there's a separate Ottawa Declaration, the protocol that covers the landmines and its related issues and so on. So like international humanitarian law has currently entered a new changing epoch by virtue of the changing dimension of the war. So again, if I get back to the question raised by Mayantha, you are asking what exactly distinguishes international humanitarian law from public international law. I would summarize my argument saying that international humanitarian law still comes as a branch of international law, but that doesn't stop there. It goes further because why? International humanitarian law specifically focuses on the armed conflicts. So that is why in the colloquial jargon, we call it the law of war. So in Sinhalese, I can still remember that when I was studying at the law faculty, my lecturer who taught me the subject in Sinhala language came up with a very, I would say, emotional description on this topic, on this subject. Actually, the topic was taught to us by a Catholic friar, a father called Father Noel Dias. He was saying international law. He described international humanitarian law in Sinhala language called Dayaveni, Manushiya Dayaveni. That is the exact term that Father Noel Dias used in describing the very nature of IHL. So that is the summary, the epitome of my argument with regard to the distinction between IHL and international. I hope that I made myself clear. Thank you.
Thank you so much, Dr. Punsara. Now we have a better idea about the distinction between the international law and the international humanitarian law and the revolution and the evolution of this and how the current international humanitarian law became to this stage. And I have to remember to you all, this session is followed by a Q&A session. If you have any kind of questions related to this topic, please feel free to put your questions in the chat box. And again, I'm mentioning we are organizing this session to give you a proper idea about the legal aspects of this Israel and Palestine war, not to point our fingers to anyone, to define who is the person who is wrong in this question, in this problem, just to give a legal aspect and a knowledge about this exact question. So when you are giving your questions to us, please be kind enough to rephrase in a way that will be supportive to your studies. And now we are having a good idea about international law, as Ms. Eranga mentioned, and the humanitarian law, as Dr. Punsara mentioned. Now it is the time to step into the topic or the problem we are having. So, Dr. Punsara, how does the international law and international humanitarian law applies to the conflicts in the Middle Eastern countries, as specifically in this Israel and Palestine conflicts? How this is going to work and what are the sanctions that these two laws going to provide to these significant people and how it is going to work, Dr. Punsara?
I think it's a pretty complex situation what we are witnessing from the Middle Eastern ground, the ongoing the armed conflict between the Gaza, between the Hamas and the state of Israel. And as a matter of fact, the Gaza occupied territory controlled by the Hamas is a de facto state. It doesn't have a de jure stances as a proper state from a point of view of the Montevideo Convention. But nonetheless, that does not give a justification for the Israeli regime to launch massive strikes against the civilians who are being stuck within the Gaza, the war zone. So I think before we move on to the applicability of international humanitarian law in the context of Israeli-Palestinian conflict, we need to understand the slight the historiography of the conflict from 2005, because 2005 was a decisive year in the Israelis' history, as it was the year in which Gaza was abandoned by the Israeli forces, which resulted in the emergence of Hamas as the government in force in Gaza. Like after that, the Gaza, the health ministry, the civilian authority, and everything was under the control of the Hamas, which is by all means a terrorist organization. There is no doubt on that. So no one can simply describe Hamas as a liberation movement, because liberation movements do contain different characteristics which are not applicable towards Hamas. So, but don't misunderstand, I'm not trying to whitewash either the Palestinians or Israelis, but I just want to take your attention through academic lenses. So let's simply get into the topic by exploring how IHL can be applicable in this context. So basically, we need to understand Israel is a de jure state fighting with a de facto state, de facto authority, non-state actor. But does it allow Israel to attack as it wishes? That is the question. That is the moral and the legal question that we need to explore. The first and foremost, we have to understand Israel is still bound under the 4 Geneva Conventions. So also Israel had agreed, Israel had been a signatory to the extra additional protocols of Geneva Convention, protocol number 1 in 1977 and number 2 as well. But there is a slight problem which we can understand from the Israeli context, as the Israel's approach to international law is something more unique. It's something more, I would say, distinctive, because first thing is Israel does not have a written constitution in their state. The state affairs are frequently being governed by the set of internal documents coming from the Israel Parliament or the Defense Council or from the Knesset, which is known as the Council of State of Israel. And secondly, Israel's approach to international law is based on the dualist tradition. Israel is a dualist country, just like Sri Lanka and India. So whatever ratified or signed by Israel in international legal dimension will not become a part and parcel factor of Israel's domestic law. But that is besides that factor. So if you look at the humanitarian crisis, which is ongoing in the Middle Eastern front, so Israel's biggest culpability as a state is the fact that Israel has adopted something called collective punishment, which has been vehemently denied by ICRC and all the relevant authorities in international humanitarian law. So on the 7th of October, as you know, more than 1,200 Israelis were butchered by Hamas terrorists who entered kibbutz and the other states, the cities in southern Israel. But of course, that was a crime by all means. There is no justification for it. But after that, Israel opted for an operation which resulted in the death of more than 7,000 Palestinian civilians. So now my question is, even from international humanitarian law perspective, or even from international law perspective, from both the perspectives, is there a proportionality between those two events? So from one side, more than 1,000 Israelis got killed overnight, and from the other side, Israel keeps revenging for that 1,000 dead Israelis by killing more than 7,000 Palestinians every day and attacking their civilian bases, ministries and universities and even the hospitals and the extreme humanitarian conditions. So is it justifiable? That is the question. So to be very honest, from IHL point of view, collective punishment is something which has been denied, which has been abhorred by the modern standards of international humanitarian law. So, and secondly, even if Israel combats, if Israel continues its conflict with a non-state actor, such as Hamas organization, being an international state actor, Israel does not have any legal stances in targeting the civilians or civil objectives. That is something that Israel should all the time abstain from doing under the standards of the modern international humanitarian law. So, but then again, we need to understand Israel's the specific approach to international humanitarian law always has been problematic. For an example, you can see Israel has withheld its stances from either signing or ratifying from Tallinn Manual or the Budapest Protocol or any of the ongoing or most recently concluded international humanitarian the legal instruments. At the same time, it does not allow either ICRC or any other international impartial observers to enter the Gaza Strip. So that is something more inhuman. And because if you look at the geographical position of Gaza, which is the distance of Gaza is approximately 40 kilometers. So within the 40 kilometers territory, you can see more than 3 million Palestinians are being stuck. I mean, it's something unimaginable, and it reminds me of the exact situation how the Nazi Germany was, how Nazis were doing during the Second World War to the countries such as Poland and Hungary and the Romania in the Eastern European front. So this is the exact situation that happened during the Second World War period. So from a humanitarian perspective, Israel has been deliberately committing one fundamental error in international humanitarian law by not allowing the civilians to leave the territory. And secondly, it has been consistently targeting the civilian objects and moreover, the civilian populated the places such as hospitals and schools. But now the question that arises before us is, to which extent Israel can be liable for all these the situations or this tragic scenarios in the Middle East. And for that, to be very honest, my answer is something more pessimistic. Because why? If you look at the standards of international humanitarian law in the contemporary conflict situations, the bottom reality that we need to understand is always the state power. The state-centric influences are standing above the IHL rules. So you take even American intervention in Libya or Afghanistan or even Syria as examples. How many civilians got killed? How many civil objects were targeted by the American drones? But did the Americans get punished? No. On the contrary, they all walked away without being impugned, because that is the state-centric, the political hierarchical authority in the modern day world. So that is applicable to whatever going on in the Middle East as well. Imagine if General Assembly passes a resolution against Israel, it will be inevitably vetoed by the United States following day, as United States continues as the biggest supporter of the state of Israel in the Middle East. That is something which we cannot deny. And even if you look at the International Criminal Court, where the Rome Statute is based on, you can't subjugate Israel based on the war crimes, as Israel is not a party to Rome Statute or International Criminal Court. So these are the fragile questions which remains unanswered before academics, before activists, and even before the general audience. So that sometimes, I would say, raises my disappointment towards international humanitarian law as something a weaker mechanism. That is the sad and the bitter truth which we have to understand.
Sarah, for that explanation and giving that idea to the audience. Again, this is only for the educational purposes. We are not going to point our fingers to any of the parties or give our idea about how this should be. This is for the educational purposes. Dr. Punsara and Ms. Eranga, we have some questions for the Q&A sessions. And my dear members, my dear participants, if you have any questions, please feel free to send your question to the Q&A session. And we have some questions as the first one. Sir, could you please explain how UN can involve in this problem? Ms. Eranga, do we have any answers for this question?
Israel-Palestine war, this already UN plays a very significant role in addressing conflict and promoting the peace. But especially when it comes to the, I mean, we know that through UN, we have this Security Council resolutions. We can issue Security Council's resolutions as a diplomatic initiative and as a part of the mediation for this kind of conflict. So basically, the UN Security Council can draft and pass resolutions addressing the conflict. I mean, already we have some resolutions passed. They may, I mean, through these resolutions, they may call for ceasefires and condemn violence and urge parties to negotiate for peace, definitely. And also, as a part of, as the role of UN, there may be, we can have peacekeeping missions. I mean, the UN might deploy peacekeeping missions to the conflict zones to monitor these ceasefires, and then to provide humanitarian aid and to facilitate, sometimes to facilitate the dialogue between conflicting parties, right? And also they can intervene to the mediation and negotiation parts, especially through its Secretary General, or sometimes specialized envoys. They can facilitate peace talks, bringing together Israel and Palestine representatives to negotiate and mediate peaceful resolutions. And especially when it comes to the humanitarian assistance and aid, again, these UN agencies and programs like UNICEF, United Nations Relief and Work Agency for Palestine refugees, there's a specific UN program, and sometimes the World Food Program. These UN agencies provide humanitarian aids and support refugees and other essential services to affect the population. And also, as another role, I mean, we can have emergency relief efforts, right? So basically, this UN coordinates emergency relief efforts, providing food, medical supplies, shelter, and other essential services to civilians affected by the conflict. And when it comes to the legal, I mean, the legal and investigation actions that can be taken as by UN. Definitely, the UN can call for adherence to international law, urging all these definitely these two parties to respect human rights and abide by international conventions and protocols, especially the protocols, the Geneva Convention, and especially the protocols of which comes under international humanitarian law. And also, I mean, again, when it comes to the International Court of Justice, they can, through UN, I mean, the International Court of Justice mean the court of the UN, so they can give advisory opinions. So in different, I mean, through my explanation, I just wanted to say that through various approaches, the UN can intervene to the Israel-Palestine war, and already they are doing a great job, but, you know, kind of geopolitics and these kind of things are also happening. So with the powers, and I mean the politics and the powers that happens around the globe, we cannot stop those things. But apart from that, as UN, as the main organization, main international organization for peacekeeping, they plays a significant role in this Israel-Palestine war. Did I answer the question? I don't know exactly. I didn't mention any example, but just gave you an opinion how they can interfere.
Yes, of course, Ms. Eranga. I think you successfully answered their question.
Through international law perspective, I mean, what kind of consequences can be happen through this non-adherence to the international humanitarian law principles, or whatever the international law principles? The basic thing is this the violation of international obligations, especially the humanitarian obligations, the laws under the laws under the law of war, I mean, law of humanitarian law, especially these states that disregard or violate the humanitarian international law, they might face international criticism and definitely the condemnation for not fulfilling their legal obligations, especially because in my explanation at the very beginning, in the introduction also, I told you that these states, these nations, they have these interrelationships because they cannot survive in isolation. They should deal, I mean, especially when it comes to the commercial purposes, trade, and state cannot survive, right? So if there's any international criticism or condemnation happens, specifically, we can see a lot of the international sanctions can be seen if something happens. So basically, I can say such kind of things also can be applied in this Israel-Palestine war as well. So, but the thing is, again, sometimes you may have that question. So someone has, I saw that someone has asked why these international human rights organizations or human rights laws cannot be applied. I mean, why they act as deaths during this Israel-Palestine war. The basic reason is, I mean, there is kind of a hidden story under this world politics, definitely. I think Dr. Punsara explained it with this powerful nations intervention, veto power, definitely the United States supporting Israel because of certain agendas. So definitely there are, yes, we can see some kind of a lag in this international humanitarian interventions, but not only that, not only the politics, but also sometimes we can see very difficulties in accessing to the conflict zones for this international humanitarian, to supply international humanitarian aids, we can say. So that's one issue. But the question is the consequence of non-adherence. So basically, there can be international criticisms, condemnation for not fulfilling these legal obligations, and potential legal ramifications sometimes, because especially I think Dr. Punsara explained why Israel, why we cannot go for ICJ. I mean, we cannot apply ICJ laws to Israel because they haven't been a party to ICJ statute. But you know, the ICJ can give legal adversary opinions. I mean, although we cannot bind, although the ICJ cannot bind this specifically the Israel with the international, I mean, the laws, but basically they can, this ICJ can give an adversary opinion, and they can, to a certain extent, they can intervene to this the Israel-Palestine war through a legal ramifications, and also yeah, such kind of things can be happened. I don't know, maybe Dr. Punsara can give a better explanation on humanitarian aspect. I mean, apart from that, we could see especially this diplomatic isolations and sometimes multilateral pressure can be seen. I mean, if other states who, I mean, for an example, if United States is supporting Israel, then definitely United States may sometimes have a kind of pressure. They can put pressure on countries who's supporting Palestine, right? For an example, I would say. Yeah.
Thank you so much, Mr. Eranga. No, it's a clear idea. We all have a clear idea about the question and the answer now. So because of the time limitations, we have come to the end of the session. as we wrap the insightful session, I want to express my heartfelt gratitude to Dr. Punsara and Ms. Eranga Dissanayake for sharing their expertise, and a big thank you to the Buckinghamshire New University and IDMNC International for organizing this. On behalf of the organizing committee, I would like to apologize for the inconvenience that you all face because of these technical issues that we are facing current days. We all know we are in a critical situation as Palestine and Israel too. So we are going to remark the end of the webinar on Israel and Palestine war from the point of view of international law and international humanitarian law. So thank you so much, dear attendees, for participating actively to this session, and we'll meet again in another important and educational session by the Buckinghamshire New University and IDMNC International. So thank you so much. Have a nice day. Goodbye. I'm Mayantha Warnakulasooriya, signing off, your host for the day.